Picture this. You buy a timeshare in a beautiful holiday spot. And the main reason you bought it, the big selling point, was the promise of free, lifetime access to this amazing country club right next door. We're talking the golf course, the swimming pool, the whole shebang. It's all part of the deal. But then, years down the line, the club gets sold. The new owners show up, and bam! Suddenly there are fees for everything. You say, hang on, I have a right to use this. And they just shrug and say, sorry, that promise was with the old guys, not with us. Well, that exact scenario is what landed a group of very frustrated timeshare owners in the UK's Supreme Court.
So that brings us to the big question the Supreme Court had to answer. Can a promise to use your neighbor's fancy leisure facilities, the pool, the tennis courts, actually last forever? Does it stick around even when the property changes hands? We're about to dive deep into the case of Regency Villas versus Diamond Resorts, a real clash of the titans, where centuries-old property law came head-to-head with the very modern world of holiday timeshares.
Okay, so here's how we're going to break it all down. First, we'll look at the initial promise, your neighbor's country club. Then, we need to get into the nitty-gritty of the law with the 4 rules for easements. After that, we'll see how this all kicked off in a timeshare and a dispute. Then we get to the main event, the legal arguments from both the majority and the dissent. And finally, we'll wrap up with the final ruling and its impact. Let's get into it.
Right, let's pop the hood and look at the legal engine driving this whole case. To really get what's going on, you have to understand this ancient legal concept called an easement. Now, think of an easement as a kind of legal skeleton key. If the timeshare owners could prove their right was an easement, it could unlock those country club gates forever. But it's a key that's protected by a very specific set of rules.
So what on earth is an easement? Well, put simply, it's a right that's attached to a piece of land that lets its owner use a neighbor's land for something specific. But here is the absolute crucial part, the line that this entire case hangs on. It runs with the land, not the owner. That means the right is literally glued to the property deeds. It doesn't matter who buys or sells the land, the right remains. And that's why the timeshare owners were so desperate to prove their access to the club was an easement.
Now, you can't just call any old promise an easement. Nope. In English law, it's got to pass a famous 4-part test. First, you need 2 properties, one that gets the benefit and one that carries the burden. Second, the right has to actually benefit the land itself, not just be a personal perk for the owner. Third, pretty obviously, the 2 properties need different owners. And fourth, the right has to be clear enough that you could actually write it down in a formal deed. Now, in our case, the real fight, the legal brawl, all boiled down to points 2 and 4.
All right, enough theory. Let's get back to the story. How did all this ancient legal stuff play out in the real world? Let's zoom in on what actually happened at the Broome Park Estate, this grand old country house that was transformed into a modern holiday complex.
So here's the timeline. Back in 1980, the first timeshares were set up with leases. Think of it as a super long-term rental. This was a smart move, because a lease can legally bind the landlord and any future landlord to keep the facilities in good shape. But then in 1981, the Regency Villas were sold as freeholds. The buyers owned their bit outright. And here's the fatal flaw. They were granted the right to use the facilities, but the promise to maintain them wasn't properly tied to the land. It was just a personal promise from the developer. So when he sold up, poof, that promise vanished into thin air. Fast forward to 2012. New owners take over, start demanding money, and the fight is on.
And this really lays it all out, doesn't it? You have 2 groups of neighbors living side by side, but they're in completely different legal boats. The mansion house folks, the leaseholders, their rights were secure. They had an ironclad, legally binding promise for maintenance that passed from owner to owner. But the Regency Villas owners, well, their promise was basically written in disappearing ink. The second the property was sold, it was gone. They were left with a right to use facilities that, legally, nobody had to take care of for them.
So the whole mess climbs all the way up to the Supreme Court. The judgment comes down, it's a 4-to-1 split, and it's delivered by Lord Briggs. And what he wrote is really a masterclass on how you can take a law from a bygone era and make it work for the modern world.
Lord Briggs basically said, yes, this can absolutely be an easement. He went through the checklist. Does it benefit the land? Of course it does. These are holiday homes, for crying out loud. The whole point is recreation. He argued that the law has to be flexible. It can't just be frozen in time. It has to adapt to new things like timeshare developments. And he made the point that in today's world, sports and recreation aren't just frivolous, they have real value. And crucially, he looked back at the original deal and said, come on, it's obvious everyone intended this to be a permanent property right, not just some flimsy personal permission.
And this one quote from his judgment just sums up his whole philosophy perfectly. He said, "The common law should support structures which promote and encourage recreation rather than treat it as devoid of practical utility or benefit."
What he's really saying is that the law needs to get with the times. It should support the ways we actually live and enjoy our properties today, not be stuck in some old-fashioned mindset.
But it wasn't a slam dunk. Not everyone on the court agreed. Lord Carnwath wrote a powerful, and I mean blistering dissent. He argued that the majority had taken the concept of an easement and stretched it so far it was about to snap.
Lord Carnwath's argument was pretty straightforward. He said, look, this isn't an easement, it's a right to have a whole country club run for you. An easement is meant to be passive, like a right to walk across a field. The landowner doesn't have to do anything. But a golf course, a heated swimming pool, that requires constant work, constant management, and constant money. He felt the court was just bending the law out of shape to fix what was basically a sloppy legal mistake made decades ago. And he posed this killer question, where does this stop? Could you have an easement for free-goes on the roller coaster at the theme park next door? He saw no logical end to it.
And he just boiled his entire argument down to this one brilliant cutting line. In effect, what is claimed is not a simple property right, but permanent membership of a country club. He's basically saying, let's call this what it is. They're not asking for a simple right of way. They're asking for a free, perpetual country club membership, and that is a completely different animal from what an easement was ever meant to be.
So now that you've heard from both sides, let's drill down into the absolute core of their disagreement. It all came down to this one single traditional rule for easements: the idea that the owner of the land that has the burden on it must be allowed to remain passive.
Okay, so here's the clash. On one side, you've got Lord Briggs and the majority. They took a very strict, almost academic legal view. They said the grant doesn't legally force the landowner to do anything. They could let the golf course overgrow and drain the pool. The right is just to use whatever's there. They even suggested that in theory, the timeshare owners could pop over and mow the grass or fill the pool themselves. But on the other side, Lord Carnwath is basically saying, get real. He argued that in the practical world, a right to use a golf course is completely useless unless someone is actively maintaining it. The idea of a bunch of holidaymakers trying to maintain a championship-level course, he saw that as a total fantasy.
So after all the legal back and forth, where did the Supreme Court finally land? And more importantly, what does this huge decision mean for property law going forward?
Well, the final vote came in. It was 4-1. The majority view, led by Lord Briggs, won the day.
The timeshare owners won. The court officially declared that their right to use all the recreational facilities was a valid legal easement. And that meant it would stick to the land and bind every single future owner of that country club.
And there was one final twist. Remember the new indoor pool that was built years later in a different spot? A lower court had said, nope, your rights don't cover that. But the Supreme Court disagreed with that too. Lord Briggs argued that the original promise wasn't for a specific list of buildings, but for the leisure complex as a whole. He said that meant the right could evolve as the complex evolved. So yes, the timeshare owners got the right to use the new pool as well. A total victory.
So, when all the dust settled, what are the big takeaways? First, it's now official you can have an easement just for recreation and sport. That is a major development in property law. Second, it shows our old common law can be surprisingly flexible when faced with modern ideas like timeshares. But it's also a massive red flag for lawyers and developers. If you try to use old legal tools for new, complex setups, you better be crystal clear or you're asking for an expensive legal battle. And maybe the most important lesson for all of us is this: there's a huge, huge difference between what you expect to get when you buy something and what the seller is actually legally obligated to give you.
And all of this leaves us with one final fascinating question that gets to the very heart of how law works. In a world that's changing faster than ever, how far should we stretch these ancient laws to fit our modern lives? This case gives us one very bold answer, but you can be sure the debate is far, far from over.